I think Matt Shea is my favorite politician in this state. I wish him well. I hope he has a great future. We could use his leadership in lots of different places. The most important thing we do on the Washington Supreme Court is to apply and enforce our state constitution. The Constitution begins, all political power is inherent in the people, and governments derive their just powers from the consent of the governed and are established to protect and maintain individual rights. Wouldn't it be wonderful if our state government did what the Constitution says? So a lot of us aren't very aware of the state constitution or our Declaration of Rights. I've reprinted a few copies of the Declaration. It's where you signed in for this program. It's for free. I'd like to talk about a little bit about where those words came from, what the ideas were behind those words, what they mean, what we can do to preserve our heritage of liberty, the role of the courts, and finally, most important, what you can do to help liberty out. So let's begin with Patrick Henry. I think he said it best. When the American spirit was in its youth, the language of America was different. Liberty, sir, was then the primary object. We are descended from a people whose government was founded on liberty. Our glorious forefathers of Great Britain made liberty the foundation of everything. That country is become a great, mighty, and splendid nation, not because their government is strong and energetic, but, sir, because liberty is its direction and foundation. But the Founding Fathers recognized that there was a dilemma. The government that can protect our liberty may be big enough that it can destroy it as well. George Washington put it this way in his farewell address: "Government is not reason, it is not eloquence, it is force. Like fire, it is a dangerous servant and a fearful master. Never for a moment should it be left to irresponsible action." Alexander Hamilton in Federalist Number 51 put it this way: "In framing a government which is to be administered by men over men, the great difficulty lies in this: you must first enable the government to control the governed, and in the next place oblige it to control itself." That's still the dilemma today, isn't it? Well, when we hearken back to those words I read from the beginning of the Washington State Constitution, don't they sound like this? "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed." The Declaration of Independence tells us what the purpose of government is. The United States Constitution does not. In 1889, Congress passed an enabling act inviting the state of Washington to propose a constitution for admission into statehood. It didn't say much about what that Constitution should say, but it did say one thing, and that it must be faithful to the principles of the Declaration of Independence. And that's where Article 1, Section 1 comes from. Governments are established to protect and maintain individual rights. But you know, the Constitution in words is a great thing. But remember, they're only words on paper, unless we have a strong and independent judiciary to apply those words to our fellow citizens and to the government itself. James Madison in the Federalist Papers said, "The conclusion which I am warranted in drawing from these observations is that a mere demarcation on parchment of the constitutional limits of the several departments is not a sufficient guard against those encroachments which lead to a tyrannical concentration of all the powers of government in the same hands." And his solution for this was a strong and independent judiciary to hold the government to its side of the contract we call the Constitution. He said, "Independent tribunals of justice will consider themselves the guardians of those rights. They will be an impenetrable bulwark against every assumption of power in the legislature or executive." So, ladies and gentlemen, the judiciary has a role to play. The role of the judiciary is to make sure that the government functions within its constitutional limits. Hamilton wrote in the Federalist Papers that limited government can be preserved and practiced no other way than through the medium of courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. Patrick Henry considered it, and I quote, the highest encomium on this country that the acts of the legislature, if unconstitutional, are liable to be opposed by the judiciary. That is the role of the judiciary. That is my job description on the Washington State Supreme Court. Before I went to the court, I was in private practice for 26 years. I represented all kinds of different people. I represented property owners, for example. I usually started my litigation by losing and then appealing it. I was a very poor loser. And I got to the Supreme Court on various occasions, and we started winning some cases. So then lawyers invited me to give seminars on property rights. I remember the title of one of them was Staking the Vampire, How to Sue Local Government. I was also the attorney for various gun groups, like the Second Amendment Foundation and the Citizens Committee for the Right to Keep and Bear Arms. But as a private lawyer, I could only advocate for the rights of my clients. I couldn't protect them. That was up to the court. In 1995, Governor Lowry accepted the resignation of a Supreme Court justice and appointed someone to take his place. I thought, this is the time when I should run for the Washington State Supreme Court. My ex-wife now told me that I was wasting community funds and I didn't have a chance. And indeed, I found out that there were 13 daily newspapers only because 12 endorsed my opponent. But you know, at the end of the day, I won that election against an appointee from Governor Lowry. And now another individual who was appointed by Governor Lowry that same year, who lost his election, is running against me. So there's quite a contrast between the two candidacies. During the last 15 years on the court, I've sat on 2,000 cases, had a record number of over 570 opinions that I wrote. I stood up for your rights when I was in the majority, I stood up for your rights when I was in the minority, and I stood up for your rights when I had to stand alone. I think I have the strongest record on property rights of anyone in the court. Not only do you have a right to own property and a responsibility to pay taxes on your property, but you know, I think that you actually have a right to use property. And I realize that's a radical position now. Freedom of religion. The state constitution is very strong. It says absolute freedom of conscience in all matters of religious sentiment, belief, and worship shall be guaranteed to every individual, and no one shall be molested or disturbed in person or property on account of religion. Well, you know, it's kind of controversial where a Muslim community wants to cite its mosque in New York, but nobody contends that they can't cite a mosque someplace in New York. Contrast that with Clark County, who zoned against establishing a church in every single zone. That case went to the Washington Supreme Court. It was decided against the church 8-1. I was the lone dissent. I relied upon this provision of our state constitution, which says what it means and means what it says. I believe our constitution must be interpreted according to its plain text and ordinary meaning, and that a county that says it's illegal to establish a church is just in violation of the state constitution. A moment ago, I mentioned the right to keep and bear arms. P.J. O'Rourke, when addressing this, said it best.